Please welcome to the stage Maria Casoria. She works at Euro University of Bahrain. I'm just going to introduce you, is that okay? So, Dr. Maria Casoria is an experienced academic university administrator. She's an independent legal business consultant with extensive work experience across the continent. She's earned a bachelor's law and international organisation and a PhD in markets law, all from a University of Siena, Italy. In addition to her academic experience, Dr. Casoria has been a general counsel and legal advisor in Bahrain. Give her a warm welcome to the stage. Thank you.
Good afternoon, everybody, and I'm very happy to be here. I would like to thank the World Lawyers Forum for their kind invitation to speak. So, as it has been said, the title of my presentation is Distribution Agreement as Monopolisation Insight from the United States versus Google case, usually referred to as Google search case. Now, you might be wondering, otherwise I can shout like the previous speaker. I'm quite happy with it. Can you hear me now? All right, better. So you might be wondering why, although this is a forum happening in Bahrain, I chose a topic that comes from a jurisdiction that is so far away from Bahrain. Well, there are at least two reasons. First of all, because those of you who are experts or know something about antitrust or competition law know that this is considered a groundbreaking case in perhaps the last 25 years in the US antitrust history. And second of all, because depending upon the final decision that the judge will render in the remedies trial, which is currently ongoing, the ruling has a potential to affect Google's operations worldwide, because one of the proposals is to basically break up Google, and as a result, all of us as users will be affected should the remedy imposed by the judge be, as I said, the divestiture of Google. So what I'm going to do in the next 25 minutes is to give you a brief overview about the ruling, the key findings, and then the proposed remedies by both the plaintiff and Google, of course. What is the provisional impact on of this decision, and share with you some final thoughts. If there are any questions at the end of my presentation, because in some time we are going to have a panel discussion on antitrust and competition, perhaps I will pick the questions during the panel discussions. This said, so overview of the ruling. Now, the ruling has been rendered in August last year, and it is about a 300 pages decision, so it's very long, it's very thorough, and as a result, because as I said, this is a groundbreaking decision, the Judge Mehta, the one who ruled in this case, is becoming very famous amongst antitrust lawyers. Now, what is the violation? Why Google went up for this case? Well, the violation is basically a monopoly violation, which is against Section 2, as you can read, of the Sherman Act. Now, the Sherman Act is the US antitrust law, is the main one, and is also the oldest antitrust law in history. And what Section 2 basically says in a nutshell is that any monopolization or attempt on monopolization, so basically the attempt to become a monopolist, if it is not the result of business acumen, but is due to anti-competitive practices, it is prohibited and is considered an illegal practice. Now, how in this case Google maintained its monopoly power? Through the conclusion of some exclusive distribution agreements with various operators in the market, such as Apple, such as Samsung, all the Android developers. And so you can, just if you think at the names, you can understand that the conduct that Google has been performing over the years is really something problematic in the United States and abroad. Now, what are the impacted markets? Because, of course, whenever there is an antitrust violation, then it is important for the either antitrust authority or for the judge to identify the relevant market. This is a requirement to find out whether or not a violation occurred. So we have two relevant product markets in this case. One, it is general search services, so basically us looking for something and just Googling it. And the second market is the market of general search text advertising. So basically, the text ads that appear on the landing page when you Google, I want a flight from Bahrain to London. All right, so again, based on the relevant markets, you can understand that this is something that, after all, affects everybody. So Google entered into a series of agreements that the judge categorized in two groups. One group are agreements related to search, so browser agreements. The other ones are agreements particularly entered into with the Android developers. And what the decision basically says is that through these agreements, Google became the default out-of-box search engine on basically most of the devices that we are using. So if you buy a new iPhone and you go on Safari, has a preloaded search engine, you will have Google. Of course, we can try and use alternative general search engines, but who is so proactive as a consumer to go and just change the default status that Google has acquired? Now, as a result of these agreements, Google managed to basically exclude potential rivals. So nobody in the market had any incentive to develop alternative general search engines. Of course, we know that there are still some competitors such as Bing, but are really minor when compared to Google and to the massive amount of data users that Google has. And as far as the general search text advertisement market is concerned, because of foreclosure, so because of the absence of rivals, Google over time has been able to charge supra-competitive prices to the advertisers. Now, as I mentioned already, the judge applied the Section 2 of the Sherman Act, but also a very important predecessor in US antitrust history, that is the Microsoft case. Those of you who deal with antitrust will remember this case. This is the case where Microsoft was found liable of monopolization because of restrictions related to Windows and, of course, all the Microsoft programs. Why everybody thinks that this is a revolutionary ruling from the perspective of antitrust? Because usually distribution agreements are assessed from the perspective of collusive cartels. So whenever entities enter into agreements, the lens of observation of the antitrust authority or the judge, if there is a legal battle, is understanding whether or not that agreement has produced anti-competitive effects and the privileges for both parties. Here instead, the angle of observation is different because the judge says, wait a minute, it's true that these are distribution agreements, but these are agreements that basically helped Google to be Google. So what the judge within the lines says is that Google didn't partner with the different operators telling them, oh, I'm the best general search engine, but because in accordance to these agreements, Google has been paying revenue shares, a lot of money, I mean, billions and millions of dollars, in order for the counterparts to keep Google as the default. Now, the other peculiar element of this ruling is that although the court found Google liable of monopolization, it refused to impose sanctions. That, again, is a little bit awkward. And the sanctions that the plaintiffs, the DOJ, the Department of Justice, was asking are sanctions related to some of the business practices, corporate practices implemented by Google, such as deleting the chats of all employees within 24 hours. So what the plaintiff basically submitted to the court is, Google had this policy in practice because they knew they were doing something wrong, something that could potentially lead to an antitrust violation. And as a result, they kept deleting the chats. And this continued also after this case was filed in 2021. But again, the judge refused to impose sanctions because basically he says in his opinion that the anti-competitive effects or additional anti-competitive effects of this practice have not been sufficiently proven. And also because even if those effects were there, the judge will not have changed his opinion about the fact that Google monopolized the market, so basically used this agreement and all the connected practices to be a monopolist and to keep its monopoly. The last reason why this opinion is really important is because, as I mentioned, Judge Mehta has merged together Section 1 and Section 2 of the Sherman Act, so monopolization and competitive cartels. And as a result, if you read the decision, at times it seems that is stretching a little bit the wording of the law. Now, another very important element in this decision is that the judge en passant, so just in a few paragraphs, brings up two additional topics that are somehow related to competition law if analyzed in the wide context of identifying the market, but the judge just says, these are problems, but then he doesn't really do anything with them. So the first point is the possible impact of artificial intelligence on search, So we are all using AI tools, we use chatbots, now we use ChatGPT sometimes to do search rather than going to Google. So how that affects, the fact that now we have new operators, new technologies in the market, how does that affect Google's power? And the second concern is about the privacy. We all know that the data are considered, we always say data are the new oil, all right? And so because Google has a huge access to a huge amount of data, then the problem is how do we make sure that the privacy of the users is protected. As I said, in the opinions, these are just problems that are described, but then the final decision does not take those into account. And so in terms of key findings, as I said, in terms of relevant product market, we are dealing with two markets, and these two markets were identified through what is known as the brown shoe practical indicia test. This is a test coming from this famous case where basically in order to identify a product market, the judge has to look at criteria such as a brand recognition and the production facilities, how unique that product is, what is the sensitivity to price changes related to that product. As far as the geographic market goes, it wasn't contested between the parties that the conduct happened in the United States. And why the judge found that Google actually monopolized the market? Because after applying principles of economic competition, so again, if you look at the ruling, you will see there are a lot of calculations. In this case, we had plenty of witnesses that testified about the practices of Google, implemented by Google. And so the court found that in order for rivals to enter these two relevant per market, it is very difficult. There are high barriers that are, for instance, high costs to access the market, the fact that Google controls basically the distribution channel, the fact that Google has, as we all know, brand recognition, and of course, the fact that Google doesn't give access to scale, where in this case, scales are the data of the users, and as a result, the judge ruled that these agreements are exclusionary because they produce three main effects: market foreclosure, impact on rivals, and also reduce incentives in investment and in the innovation of products. Because of course you can understand that if I am a monopolist, I am the only one, or one of the very few in this market who is offering a service, I will not really have an incentive to improve, to make investments and improve my products, because the consumers will not have any choice but to use my products. Of course, Google, as you can expect, tried to give a lot of pro-competitive justifications. They can be summed up by saying that Google tried to make the point that instead these products are innovative, and so Google is a monopolist because it's good and the others are bad. And so because it's good, the users are basically using its products. And there is also a point about business partners getting advantages from the partnership with Google. An example is the one I mentioned on the slides, that is to say the agreement with Apple that allegedly produced some benefits for Apple in terms of security features. And so in the end, the court said these are not really sound justifications, especially because Google was not able to properly prove that submit evidence in support on its claims. The violation is proven in the opinion of the judge, and as I said, despite this, the judge said, I'm not imposing sanction, but then the last sentence is, the fact that this judge doesn't really impose sanction doesn't mean that in the future any court will take the same approach. So it seems a kind of warning to Google against this practice. Let's go to the next step, the one that is currently ongoing. As I said, according to statute law in the US, if an antitrust violation is found, the next step is for the court to decide what are the most appropriate remedies. And before the trial kicks off, both parties have the opportunity to submit proposed final judgments to the court. So what the plaintiffs, what the Department of Justice, so the US government basically proposed. Now, the proposal is very harsh because they are proposing structural remedies, that is to say, breaking up Google and the divestiture of Chrome from Google. And if that did not work, they are also, for a period of 5 years, they are also asking the court to then break up all the operators that produce Android devices. So again, if you think the possible structural remedies, you can understand that these might affect companies and us as users outside the United States. Other remedies, more behavioral remedies or injunctive reliefs, are kind of classic remedies in a sense, because they go from prohibiting Google from entering in similar agreements in the future, from paying business operators a revenue share, and also a prohibition of self-preferencing, that is to say Google basically displaying its own products at the top of the search results, and also stopping the default placement in distribution. When it comes to the next market, that is to say the general search text advertisement market. So here the plaintiffs are basically trying to propose remedies that will allow the advertisers to have better control over their ads and also better access to information. And in addition to being able to use possible rivals of Google. Now, another very important remedy is the data sharing obligation. This looks like a regulatory remedy because basically what the DOJ is proposing is for Google to give up almost for free all the data they have, and because again data are assets, of course Google is really opposing this kind of remedy, which brings us to the next point. What Google is asking the judge to do. Well, Google proposal is of course a very soft proposal because it basically focused on the licensing requirements. And so what Google says is that Google will allow its business partners, in particular Android partners, to use more freely its products, to go to rivals, to refuse to preload Google as a default, as it currently is, not just in the ad markets, but also when it comes to using AI chatbots. So they say, that Google has developed Gemini. And so they're saying if a partner wants to buy some of our products, they will not necessarily be bound to also set as a default Gemini, but they will be able, all right, to use other products. And so to remedy this issue of the default, so the default placement of Google, they are also promising to implement a new policy whereby business partners will be allowed to set Google rivals as a default, and they argue that this policy might have might produce a potential increase in competition because it will give also more choices to the users, and as a result will increase consumer welfare. This said, the ruling is ongoing. We don't really know what Judge Mehta is going to do. Of course, Google has already announced they will appeal the decision. So we cannot really, at this point in time, foresee what is going to happen. But the ruling is already producing some impact. April is a great month in terms of impact. So thank you very much for setting up the forum in April, because a lot of decisions against Google are coming up. So we have a new decision in the United States, as was rendered a couple of weeks ago, is again against Google. It is again monopolization, although the market is different. It is advertising exchanges and the publishers at the servers. Here, the case is not just about monopolization, but there is also an allegation related to anti-competitive cartels. If we look at the impact outside the United States, so in January, the Competition and Market Authority, that is a regulator of competition in the United Kingdom, launched an investigation against Google just to assess Google's market powers in search and advertising and the impact of Google conduct on businesses, advertisers, consumers, and publishers. And a couple of weeks ago, we had also a class action filed in the UK against Google. The allegations are related to dominant positions, and as things stand now, the potential damages Google will be condemned to pay might go up to £5 billion. If we look at the European Union, of course, this is a jurisdiction that has been very active in terms of regulating big techs, so Google as well. And the very last issue we had is a claim submitted again in mid-April by a German media company to the European Commission against one of Google's policy, that is the site reputation abuse policy. And because according to this company, basically the policy allows third-party content to be displayed in a different ranking depending upon Google's preference. And so it sounds like, if you read their complaint, that they're saying Google is abusing of its authority. In conclusion, so Google in the United States, in the Google search case, has been accused of having put together a revenue share funded monopolies, and so the problem is that he has not become a monopolist and maintained its power because, as Google says, its products are superior. We can disagree or not as consumers, but these are the findings of the decisions. And of course, the other problem is that Google controls the distribution channels when it comes to search and advertising. And the key aspects of the Google search case are, of course, how do we ensure fair competition in digital markets? This is a problem different antitrust authorities worldwide are discussing. What is the role of data in digital markets in relation to market power? And of course, because AI is becoming really prominent, how AI will impact search engines and how everybody does a search. And last but not least, when it comes to digital markets, what the legislators can do in order to strike for a balance between innovation, competition, and consumer choices. If you are interested in this topic, I have a publication coming up, so just drop me an email, and once my paper is published, I'll make sure to send you a digital copy of this. So thank you very much for your attention. As I said, I will pick the questions during the panel discussion. Thank you.
Thank you to Dr. Maria Casoria.